Hello everyone, welcome back to another episode of the Darrell Brooks saga. In today's episode we're going to continue with the meltdown that he had after the smoking gun tactic didn't work. So let's get right into it.
Start with that jury instruction conference. We'll take about 10 minutes. Thank you everyone. We are in recess.
He was on the other
continues to
courtroom.
appear from the other courtroom. I would like to make a record regarding the audio and visual from the other courtroom. I've asked that one of the bailiffs who was present during the last session, present in that courtroom, come to this courtroom. I'm going to put him under oath and have him testify about the audio. I also have information from Zach Tremaine, our IT specialist. He too will take the witness stand. Thank you. And you are a Waukesha County Sheriff's Deputy?
I am.
And have you been assigned to work this case?
I have.
And were you present in courtroom 20 this morning with Mr. Brooks when he was removed from this courtroom to that courtroom?
I was.
And did you make any personal observations regarding the audio and visual setup that we have over there?
Both the audio and visual were working properly. The audio was a lot louder than it has been in the past while we were in that room.
Did you have any difficulty hearing the court?
I did not.
And then, of course, you could see through the cameras from this courtroom into the neighboring courtroom.
I could.
All right. That's the only record I wanted to make. State, have any questions?
Just briefly, Deputy Kibler, the defendant asked many times if he was muted or unmuted. Do you remember that?
Yes.
Can you confirm that even on the occasions when his microphone was muted, the audio in the courtroom continued to work?
It was.
And at any time while Mr. Brooks was muted, or even if you didn't know, at any time did Mr. Brooks ask to be brought back over to this courtroom, sir?
He did not. He is telling us he prefers right now to be in that courtroom. He did not want to come back in here.
All right, thank you. Those are all my questions, Your Honor.
All right, so they just called him to establish, because he was saying stuff about wasn't able to hear him correctly and all that stuff, and they just bring that deputy to say, no, it is working properly. He can hear. He's just playing.
Mr. Brooks, you are unmuted. Do you have any questions for this deputy?
No.
All right, thank you. You may step down. All right, then I'm going to have Zach Tremaine also take the witness stand.
I'm the IT coordinator for the Waukesha
Hey,
County
IT.
Circuit Courts.
Were you in courtroom 20 this morning following Mr. Brooks being taken to that courtroom?
Only temporarily. I was there when the call started, and then we came back to do a measurement of the DB meter later.
There's a document or a photograph that's displayed on the monitors throughout this courtroom. Can you tell me what we're looking at?
So my phone is in the photo, overlaid on top of what we call the X panel. It is our AV control panel. So you push buttons on it and actions happen into the courtroom, AV related. At that time of the photo, my phone is registering 67.3 decibels in that courtroom, and that was when the judge or the court was talking, and then the sound was coming over the speakers in the other courtroom.
And what, if anything, based on your training and experience, can you tell me 67 decibels means?
It's plenty loud. For comparison, I did a quick reading in the media pooling room, which is CG6 in our courthouse. The meter there was reading between 55 and 65. So it's louder than the audio feed going to the media right now.
Your Honor, for the record,
So it's louder than if he would have been in that courtroom, and he claims that he can hear correctly in that courtroom.
this photo will be made a court exhibit?
Yes.
Okay.
Mr. Brooks, any questions for this witness?
Yeah, for the record, I don't consent to being called that name. Do you know anything about the hearing when someone has hearing loss in any of their ears?
I do not.
He's not a doctor.
So it'd be fair to say you don't know if I can hear everything good from this courtroom.
I can tell you what the readout of the room is. Beyond that, I don't know.
Well, I can't see what photo that everybody else is in there seeing that was supposed to be made an exhibit. I have not viewed that, so I don't know what's being referred to when you refer to the picture.
I'll have to show you that in a different way. I don't have the Zoom up and running, which would have been the mechanism to allow for an exhibit to be displayed. I can start that and have that up momentarily. Fair enough.
There was no reason for him to see that. He's not gonna even understand
All right,
what is
now
in it.
the court is sharing screen and the image is being displayed.
Yeah, I see it.
You see it? Okay, thank you. Any questions regarding that then, sir?
You don't know if me myself can hear everything good in the courtroom, correct?
I do not, correct.
No further questions.
Okay, thank you, sir. I'll stop sharing. Okay, thank you, Zach. You can step down. Now, I need to get a copy of the jury instructions. They were quite lengthy. The record should reflect that Mr. Brooks was provided with a written copy. It's 107 pages, and the state was provided with a written copy as well. Again, it's all the same, 107 pages, and then my written copy is on its way.
I assess the value and return the value of each document.
107 pages of jury instructions. That's gonna take a while.
That's if
And he has to review all of that, and he's not gonna do it.
I'm not muted.
You're not muted.
I also would like to, again, ask for subject matter jurisdiction to be proven on the record.
No.
Your request is
It
denied.
has yet to be verified. It has yet to be verified.
Your request is
Your
noted.
Honor,
It's denied without further hearing or consideration.
I was just told that, the evidentiary phase is supposed to be closed. How come I haven't been able to present my evidence into the record as I've asked numerous times on the record to be able to do? I've said I have numerous documents that needed to go into the record.
All those documents have nothing to do with this case. It has something to do with the trial, but that's not what we are here for.
Why have they not been permitted to be made evidence? I didn't rest my case, so I don't know why that's being told. And I have yet to be able to offer my exhibits into the record for evidence. How is that so, Your Honor?
I specifically found that you forfeited your right to present any further evidence or testimony when you failed to answer my questions regarding the calling of witnesses. And then I also declared that you forfeited your right to testify. Specifically as it relates to your trial filing, sir, I would note that all evidence in a trial must be proper, it must be probative, it must be relevant, and it must follow all rules of procedure and all rules of evidence. To the extent that you wrote all of those documents, sir, that would be hearsay. And for that reason, I'm denying your request to make them part of the record.
They were not hearsay, Your Honor. I did what you told me to do. You told me
He just literally was told what they were, and he's like, nope, they are not. A judge just told you what they were, so you take it.
since I was representing myself pro per, that I had to write everything out and present them to the court.
So that's not what I said. You're misquoting me, but in any event, I'm
No, that's
denying
what
your
you said.
request.
The gaslight is real.
I
So
said,
you're saying that I have no right to present evidence and to have exhibits as the state's been able to do.
He never said
Mr.
that.
Brooks,
Are
I'm
you
not
denying
going to
me my-
have a debate about this
Are you
now.
denying me-
I gotta
are you
mute you
denying
once
your
again.
right?
So, Mr. Brooks, I have muted you because I declared the evidentiary phase of this trial closed. You forfeited your right to present further evidence and testimony.
I love that he's yelling and he's muted. That's the greatest feeling.
Previously by refusing to answer the court's questions. I will specifically address the filings. Number one, it is not true that I advised him that any filing would become evidence. That is simply false. Number two, filings, I told him if he wanted to present motions, should be written down and should be based in law and fact and request specific relief. I'm well aware that previously he has referenced he would like his filings made exhibits. I've reviewed those filings. There's nothing relevant, nothing probative, or the information contained therein is hearsay.
So that's the reason why he cannot present evidence. He already reviewed those documents, and none of them are evidence.
Mr. Brooks would have needed to testify regarding any statements that he, from himself, testimony. He cannot simply put in an affidavit. That's not proper. That's hearsay. And he hasn't asked in any of those filings that he hasn't put forth.
And notice how he's reacting to all this information, and he doesn't have the headphones.
Any exception to the hearsay rule that would allow this court to admit his written filings. I believe without fail they are all irrelevant, not probative, and hearsay, and therefore not admissible. So we're moving on to the discussion of jury instructions. When Mr. Brooks wants to abide by the rules of decorum and civility, I will unmute him. He clearly just took the entire packet of jury instructions and put them, I don't know what's under the table, if it's a garbage can or if he just simply put them under the table, but they are no longer in front of him. I will, however, unmute him so that we can get his feedback regarding jury.
But now he's literally a child. He just threw the documents on the garbage and he's like, nope, I'm not going to address him. I'm going to cross my arms and pout.
Instructions. It's typically a back and forth. We'll go through them, and I'll ask the parties whether there are any instructions they believe should be included, and we'll have a discussion on that, and then we'll talk about whether any of the instructions that are in here need to be modified in any way, taken out, edited, etc.
Muted.
All right, you're unmuted now, but you have to not interrupt.
You can't, I'm not trying to interrupt, but how can you deny me the chance to put on the adequate defense by saying nothing that you told me to do can be presented into evidence? So you filed them, you filed everything that I gave to you,
Right,
filed.
Mr. Brooks,
She has to file them. You presented them. She has to put it on the record that you did it. But that doesn't mean that they become evidence or that they have any relevancy to the case.
I'm going to mute you because this is not relevant at this time.
It is.
He's raised tone of voice. He's very animated. He threw the jury instructions on the floor. I understand you're upset, sir. I made specific factual findings. I've referenced the law, and you being upset with the decision is not going to change my mind. He's also taken the headphones off. It's his choice right now whether he participates in this jury instruction conference. It is his choice. But if he is going to spout off about things that I've already determined, I will continue to exercise the mute function on the audio equipment.
Good. Look at that.
I'll unmute him again, but you are advised, sir, you need to be proper, you need to not interrupt, and you need to stay on task, which is we're discussing jury instructions, not other evidence, not subject matter jurisdiction, not your belief that I told you to file things a certain way. We are now discussing jury instructions. So once again, I'll unmute him to see if he can follow these simple rules.
You need to tell me why I can't present evidence.
He just told you that she reviewed those documents and none of them were evidence.
How can you deny me the fact? How can you deny me my right to present evidence?
All right,
I
I will
told
mute
you
him
before
once
this.
again because he wants to continue. And again, I understand he's upset. I understand that. But he has himself to blame for his conduct this morning and the rulings that I've made. All right, so let's go through these jury instructions.
Here we go.
Has the state received a copy of the draft?
Yes, Your Honor.
Thank you. Mr. Brooks, do you acknowledge receipt? I believe you did by acknowledging it previously, but do you acknowledge receipt of the draft of the final jury instructions?
I didn't acknowledge nothing, and I don't acknowledge anything now. I have not received anything.
I would ask the
Yes, you did.
bailiff to
I
pick
don't
up the
receive.
documents from the floor and put them in front of him.
And
once again.
I'm not presenting it to nothing I don't give my consent to. You can't deny me the right to put on the defense. How can you tell me when I done stated
I'm going to
3
read
or
it
4
once
times?
again because, again, I understand he's
I love that he did this for the camera. I love that he took the trash can and literally got in camera and pulled them out. It's a great touch by this deputy.
upset. If the bailiff could confirm, well, he put him on top, he put him on the floor. That's his right. They're not in front of him, but it's by his own conduct that he's done that.
And again, when people say in the comments that he could win an appeal, just listen to this record. When she's saying that he put the documents on the garbage and then she asked them to put them back on the table, and then she tells that he threw them again. A judge is gonna read that and it's gonna be like, this guy is playing. He's never gonna win an appeal.
I know one of the things I probably need to look at, I'm not sure if Madam Clerk did this or not, would be the language from the
You put them in the
amendment
garbage
from the
again.
amended information. On count 70.
Okay, I didn't know that this moment was coming so early in this day. So I'm gonna do this. I'm gonna put myself over here. And then let's see what he does.
No, I don't want to do that.
Oh, you don't? I changed,
Hold on. 76. The 76 count. Just want to make. It says near Frame Park, so it is in there. But that was just one question I.
He almost falls down. Can you imagine if he falls down with this box on top of him and injure himself? Because those are heavy boxes. That's why he cannot lift them. But can you imagine the court, like, the judge needing to not laugh at that?
I had. All right. There's 107 pages. I certainly can give the parties some time to continue to read through them.
I put 375, 141, and 172 at the end.
Mr. Brooks is requesting to go back to his cell. At this point, I'm going to deny that request.
No, you can't escape. You cannot escape. He's yelling. You can tell he's yelling. He's so upset right now. He just put a fort, basically. It's just no girls allowed in front of it. But what he's doing right now, while they are
I know
watching...
he's muted, but I can certainly hear him from this side. He appears to be yelling at the top of his lungs. I can't decipher what he's yelling.
Yeah, you can hear it. But why would you do that? Why would you forfeit your right? You're just defaulting to whatever they want to do. Defend yourself, my guy. You have that opportunity. And now he's playing with this in his little bed with a box. With a fort built of boxes. I really wish that they could leave him alone. Like, chain him to the table and just leave him there. No bailiffs for him to
Mr. Brooks, if you
yell
have
at.
specific instructions or categories of instructions that you believe this court should consider, I need you to write them down on a piece of paper. If you don't have, I believe I see a writing utensil. I'm not sure if I see a pad of paper. We'll make sure you have that. But given your current demeanor, which is still seems quite animated, and a loud raised voice, I'd ask that you write it down.
Oh, he took the jacket off. It's on now. How is this helping him? He keeps pounding the tables. He's like, ah. I really wish that someone had to, like, type down what he's yelling over there. It will be fun to just listen to what he's trying to say. And everyone else is just moving on with his day.
I just want to make a continuing record that Mr. Brooks is still, I can still hear him even though he's muted due to his level, his tone of voice and volume level that he is using from the neighboring courtroom.
Maybe that's the reason why he has hearing
Mr.
loss.
Brooks, I'll advise you once again if there are any specific requests for either instructions or categories instructions that you want this court to consider, please write a note to pass to the bailiffs who can let me know.
And again, this is the edited down version, so I don't know how long he was yelling. Could have been hours.
Do you have any requests as it relates to instructions that are not in the packet that should be?
No, Your Honor.
All right, let me turn to Mr. Brooks just to get whether he has his list. I'm not asking for a response yet, Mr. Brooks. What I'm asking you for is whether you have any requests for jury instructions, or if in your review you think anything needs to be changed, deleted, added, etc. I know I'd ask that it be put in writing, but I'll also give you this opportunity to verbally advise the court and make your requests. Do you have any requests as it relates to the jury instructions, sir? I would note he put 2 boxes right in front of where he's seated, so I can't presently see his face. I see his jacket is off because I can see the outline of his arms, and I can see the jacket on the back of his chair. He is unmuted. I've confirmed previously regarding the audio working, and I will just ask him a second time, sir, do you have any requests as relates to the draft packet of jury instructions, whether that be any additions, corrections, edits, or deletions?
He tired himself. He kind of
Your Honor,
didn't yell
would it be
anymore.
possible for the bailiffs to just move the boxes off the table so we
Yes,
can
I think
see?
that's fair. I'm going to advise the bailiff to remove the box so I can see Mr. Brooks.
Good.
I don't know what he's doing behind there. If you could move the second one because it can interfere with the microphone as well. And the third one.
Good.
Mr. Brooks, I'm going to ask you for a third time. Do you have any requests as it relates to the jury instructions? Any requests for instructions that aren't included that you believe should be included? Any edits or deletions from the packet that has been provided to you?
Hey, why do you tell them to move my body?
Because I couldn't see you, sir.
Or what?
I've asked you twice now, and I'll ask you a third time. Do you have any requests as it relates to the jury instructions? Any additions, deletions, edits, or
Hey
otherwise?
man, you don't gotta talk to me like that.
She has to talk to you like a child because that's how you are acting. So she must think that is proper.
Do you have any requests
First of all,
related
what?
to the jury instructions, sir?
Man, yeah, I got requests. It ain't like they gonna be honored though. Cause
As it
nothing
relates
I
to
did
the
fine.
jury
Get done,
instructions,
you-
sir, what are your...
I heard what the hell you said, man.
Wow. I don't know what kind of judge do when that happens, other than mute him and I guess get him out of the courtroom. But what would you respond to her like that?
Well, Mr. Brooks, that was very disrespectful.
Yeah, and I've been getting disrespected since the beginning of this whole process. So welcome to the club.
Wow.
Mr. Brooks, do you have any
I'm
requests?
tired of my race getting trampled on here too. I'm tired of it too.
Do you have any requests as it relates to the jury instructions?
Ain't nobody understand why I'm frustrated.
No, we don't understand why you're behaving like a child.
How you gonna sit up here and make decisions based on what you think I said when I didn't get consent for you to do any such thing?
She doesn't need your consent, my guy. She just needs to say it, and that's the way it is.
Sir, I understand you may be upset, and I really do,
No, you
but
don't
I've made my
understand nothing.
determinations.
You don't understand nothing. You don't understand anything, Your Honor. You don't. Because
I'm going to mute him again because he's not answering the questions that I'm very clearly asking him, and I've given him 5 opportunities. Mr. Brooks, do you have any requests as it relates to the jury instructions? I'll unmute you for that answer.
I can't hear everything you're saying.
Okay. Put in the
Mr.
headphones.
Brooks, I know the audio's turned up. I believe you can hear me. You've chosen not to put the headphones on. That's your choice. My final question to you, do you have any requests as it relates to the jury instructions?
I just told you, am I muted? Am I muted?
No.
No.
I just told you, I don't know how many times, I can't hear everything you're saying.
Then you should put the
What about
headphones
that
on.
Don't you understand? What about that don't you understand? If you see headphones, you can see everything. You can see boxes, but then you see headphones.
Have you asked for headphones to be provided, sir?
I shouldn't have to ask for them. I didn't ask for my boxes to be moved.
My guy, you decided to give them the headphones. You had them. You had them on. So, what are you saying? That they didn't gave them to you? And there they
I
are, right
believe
there.
they took them away previously because you were so agitated. They were perhaps afraid you might break
Yeah,
them.
I'm still agitated. I ain't gonna stop being agitated.
He forgot that he cannot hear without the headphones, so he responded.
That ain't gonna stop. You sit up here and do everything you're doing, and think God don't see what you're doing.
I'm not even gonna say anything.
You ought to be ashamed of yourself.
Mr. Brooks, do you have any requests as it relates to the jury
Yeah,
instructions?
I can hear what you're saying. I can hear what you're saying.
Then
You
answer.
just told me you didn't. So which one is
Yeah, I
it?
got the headphones on. You can't see that?
What are your requests as it relates? What are your requests as it relates to the jury instructions, sir?
Man, don't try to come with this whole little image, sir. Now it's all this, sir, and all this.
You always said sir.
I'm gonna get where I'm going.
We all know where you're going.
Try to put on this little act like you so worried about what's going on with me. You don't give a damn. Never did.
Mr. Brooks,
Why would she care about you? She doesn't care about you. She's a judge. She's not your mom.
you're being disrespectful again.
You've been being disrespectful. You've been being disrespectful.
I need to know what your position is regarding the jury instructions. And I need to know it now.
What you mean? Who you talking to?
I'm
You.
talking to you. I need to know whether you have any requests as it relates to the jury instructions, sir.
Yeah, first of all, why am I charged with 2 bail jumpings when I was already charged in Milwaukee for the same bail jumping? That's double jeopardy.
It's not double jeopardy. Your objection is noted. It's overruled.
It is not double jeopardy. He doesn't know what double jeopardy means. He only saw Jeopardy and he was like, "Oh, double dare. That must be double jeopardy."
It is double jeopardy. How you gonna charge me with the same charge that I'm already charged with?
That's not how it
You can't
works.
do that. The Fifth Amendment says that you can't place somebody in jeopardy of life and limb twice. I'm already charged with the same count in Milwaukee.
Double jeopardy means that you cannot be charged, that you cannot be convicted twice for the same charges. So if you're found guilty here, they're gonna drop the charges in Milwaukee because they cannot charge you of them anymore. But as far as I understand it, it's not the same. They're different.
For the same case, it's the same bail jumping charge. So how am I charged with that here?
Sir, I'm not going to provide a legal explanation other than to say I've reviewed that. Your objection is noted, but the jury will be instructed regarding the bail jumping.
It can't be because that's double jeopardy. Under the law, if two charges are identical in nature, you cannot place me in jeopardy of life and limb twice. You can't do that.
What's your next?
The same case number.
What's your next request, sir? I'm noting your objection.
I'm trying to talk. Can I get it out?
You already
You
did.
always want me to not interrupt you, but you always find a way to talk over me.
I understand your position. I'm saying it's overruled.
You always want respect, but don't want to give it. I'm charged with the same bail jumping charge here that I've already been charged with. That is double jeopardy.
It's
Can't
not.
charge me for the same exact bail jumping that I'm already charged with, that I was charged with before this even came about.
Sir, the bail jumping charges in Waukesha County are based upon your violating your bail while in Waukesha County by driving through the Christmas parade and allegedly killing 6 people and injuring 61 others.
There you go. She just explained it. Now what?
Okay.
That's the distinction.
Again, there is no distinction. It's the same charge.
It's the same offense. It doesn't mean it's the same factual basis, sir.
Yeah, it cannot be the same because it's based on what you did on Waukesha. So you didn't do that before.
Charged with bail jumping with the data violation of November 21 in Milwaukee County anywhere. Further, the double jeopardy prohibition would prevent him from being convicted twice, not charged twice.
There you go. Explain. Black and white. Thank you, Susan. And now what, Brooks? She just told you what it is.
All right, so we've addressed that, sir. What other requests do you have as it relates to the jury instructions?
No, I want to know why I'm even charged twice with the same thing. You can't charge me in pursuant to a case in Milwaukee that I'm already charged with bail jumping for. I'm already charged with bail jumping for that already. So you can't essentially say, oh, well, because you were already on bail, we're going to charge you.
It's a different data violation, sir. The conduct for the bail jumping is related to the allegation that you committed a new crime in Waukesha County while out on bond from the Milwaukee County case.
Yeah.
Yeah, but I'm referring to the first bail jumping count. The first. I'm not referring to both of them. I'm referring to one of them.
My understanding, sir, is there's different dates of violations as it relates to that. So I've noted your objection now repeatedly. I understand it. Your request to, I guess, dismiss the bail jumping counts are denied.
Denied.
I didn't say nothing about count. I said one.
Whether it's one count or both, it's denied.
Am I not being understood? You can't charge me with the same charge twice. You can't.
It's two separate cases, sir. There's two.
Isn't that 971.23? Isn't that the statute that refers to the double?
All right, sir, I'm not going to have an argument. This isn't fruitful. I understand what you're saying. You're saying there shouldn't be 2 counts of bail jumping. You believe it's double jeopardy. I disagree with that. They're separate.
I'm already charged with it, though.
This is a circular argument, sir. It doesn't change the fact that, from my perspective, the two bail jumping counts are going to proceed forward. There's been sufficient evidence presented to warrant the jury being instructed.
They can't.
What other requests do you have,
You're not
sir?
gonna talk over me. Don't talk over me. Just like you don't want me to talk over you.
Because you interrupt her so much, and now you don't want to. You don't want them to do what you do to other people. That's typical Darrell Brooks.
Just like you don't want me to talk over you. Just like you don't want me
Mr.
to
Brooks,
disrespect
what
you
other
because everything
requests
I
do
say-
you have?
And I just asked you not to talk over me.
Okay.
You've been making your record the whole time you've been over there. You had me muted.
Right.
I didn't see no requests over there. I didn't write nothing to go over there. I let you do what you was doing.
Notice how it says "I let you," like he allow her. Like that's not how she's gonna do what she wants. You don't have to let her do anything.
No matter how egregious and biased it is, I let you do
Egregious.
what you was doing. Because we both know that what you're doing is not right.
Mr. Brooks, I'm going to refocus your attention to the jury instructions. All of your objections are noted. I understand that.
Refocus my attention.
If you can't answer my question, I'm going to move on.
You can't. I haven't given you consent. Just like
All right, I'm going to mute him once again. He refuses to answer simple questions regarding if he has any requests. He just made an argument regarding the bail jumping, so clearly he has an understanding about the law as it relates to that. It may be a misunderstanding about the law and double jeopardy, but he made an argument. I've denied it. I'd like to know if he has any other requests. If he can stay on topic, I'll I will unmute him again, and he can tell me the list, just like the state went through a list. I need to get through their list. I'm asking you to list out all your requests, and then I will take each one up in turn. So here is your opportunity to give me your other requests, not debate with me about prior rulings. Go ahead, Mr. Brooks.
Don't sit up here and try to play no game talking about you giving somebody an opportunity because you haven't gave me an opportunity to properly defend myself and put stuff into evidence, which I've asked you repeatedly to do before we even got to the trial. You told me we wasn't in the evidentiary phase.
Mr. Brooks, do you have any other requests as it relates to the jury instructions? This is probably the 10th or so time I've asked you this question.
No, it's not. No, it's not. So please stop being incorrect, Your Honor. Please stop.
Do you have any additional requests as it relates to the jury instructions?
Yes.
Oh.
That first count 74 bail jumping needs to be dismissed. You can't charge me with two things. You can't
She
charge
already
me
said
with the
no.
same charge twice.
All right, I've made a note of that. What's the next issue?
Either one county gonna charge me with it or y'all, but it can't be both.
It can.
It's the same. It's pursuant to the same exact thing that I was on bail for. The same exact thing. The same exact case. So why are we giving the jury instructions on two cases from another county?
I've made a note of
He's like saying, I stole a TV on New York. You cannot charge me for stealing a TV in Wisconsin.
that. What other requests do you have?
Man, this is ridiculous. So I'm not even able to adequately defend myself, present evidence, do anything, because everything I say is gonna be found a reason for it not to be valid.
Right. And I'm gonna tell you, Brooks. I'm gonna tell you the reason why you're not being adequately represented. It's because you chose to represent yourself. That's it. If you had two attorneys with you, they would have done a better job. It wouldn't change your fate. You wouldn't have been found guilty, but at least they would have put a proper defense. So it's your fault.
What are we doing here, Your Honor? What is the
Mr. Brooks.
For? Why should I be here when
I've made a note of your request as to count 74. Do you have any other requests as it relates to the jury instructions?
Why are we even having jury instructions? Why do I have to even sit here in this courtroom at this point.
Because
Because
it's your
everything
job.
You've been doing without my consent anyway, so you're gonna find a way to do this without my consent.
You decided to be a lawyer, so you have to be a lawyer now. It's not just pick and choose when you want to be there.
So why do I need to be here for?
Your objection for lack of consent is noted for the record.
Okay, yeah.
Any other requests,
you
sir?
talk a good game. You talk a good game to save yourself enough space. But everything I put together, it has no merit in your court.
It doesn't.
None.
Nope.
All right, I've asked him many times. I've advised him, and I'll advise him once again. If he fails to answer the question, I'm moving on. Do you have any other requests as it relates to the jury instructions, sir?
You can't move on because I haven't given you consent.
You can.
All right, he did not answer. So I'm muting him again. The only request that he has made as it relates to the jury instructions, as he pounded his fist once again, raised his voice. I understand, I really do, that he's upset with my decision to cut off his ability to present a defense, but that decision was made based on his conduct and his conduct alone, as I've outlined already on the record.
He's back with the boxes.
All right, so let me go through the list
Are you gonna fall
from
off
the
again?
state. Turning to page 61.
Okay, I'm gonna sit in this chair. There you go.
So I've considered the request by the state. I am going to
What are you
rely on
doing,
what
bro?
information
I'm
they
back
put
here with
in the
you.
charging
Don't put the
document.
boxes.
I'm
Don't
going
put
to
the boxes
deny
back.
the request to include the
I'm looking straight
specific
at you.
case
Don't do
numbers.
it.
There's evidence, of course, that was received regarding the two separate cases out of Milwaukee County that form the basis for both of the bail jumping counts. It will be up to the jury to review the evidence and
Okay.
make a determination. As to the verdict forms, though, that were referenced previously, at least the description of them in the jury instructions, that obviously the third count of bail jumping is incorrect. That needs to be battery, and that change will be made. So jury instruction 70 has to do with the defendant proceeding pro se. The pattern instruction would be basically the first paragraph. I need the bailiffs to move the boxes away from his
Please.
face. I need to be able to see him. He can keep them on the table, but they need to be moved off to the side. And if he does it one more time, then I will instruct the bailiffs to take the boxes away. Those are trial prep materials. If there's something in those materials related to jury instructions, he should take those out now. Otherwise, they need to be moved away from the microphones and away from blocking his face.
I'm not putting them there. I'm not putting them there. So she can't see me. I'm putting them there for a reason. I'm nothing to do with her being able to see.
Mr. Brooks,
So he just say that the reason why he put the boxes, he didn't state a reason, but he said that it's not there for she not being able to see him. So what other thing are you saying? Like, there's only one reason.
do you have any position on the verbiage of jury instruction
Don't ask
70
me- don't
on
ask me
page
no question.
65?
Don't ask me no question. Are you my accuser? Are you my accuser, Your Honor?
All right, he's choosing not to answer, so I'll mute him again. It's unfortunate that he's deciding not to participate in this. He is currently muted. He can raise his hand and I'll unmute. Otherwise, he can
Teacher.
pass a note to the bailiff or simply tell the bailiff, who can then tell me and I can unmute him. But unless he tells me, then I'm going to assume he's made a decision not to provide further comment based upon the last statement he made to me. Then 141, I believe that's appropriate given the evidence that has been received. That's on identification of defendant is an issue. That I will instruct the jury accordingly unless there's a request from Mr. Brooks to take that out. Is there a request from you, sir, to take 141 out? I'll unmute for that purpose. It's found on page 106 because it's at the end of the instructions. This is the instruction on identification of the defendant and where it's at issue in a case. I believe it's appropriate given the testimony in this case. Do you have any position on that, sir?
It
You are
doesn't.
unmuted, so you can simply answer yes or no. No response. Then 172, circumstantial evidence, flight, concealment, I believe is appropriate given the evidence that has been received during this case.
Yes.
Yes, sir?
Am I unmuted?
You have been.
Am I unmuted?
You are.
So how long before you mute? As soon as I say something?
Depends on what you say, how you say it, and if it's responsive to what we're doing.
Why do I have to be responsive to what you guys are doing?
Because it's your trial, my guy. Your life is on the line, remember? So yeah, now you're just forfeiting. You're defaulting to what they do.
Then I say even matters at this point. So what's the point of me being responsive? You can't make decisions for me.
Mr. Brooks, I'm going to mute you unless you can participate in what we're doing, which is discussing the jury instructions.
I'm gonna tell the jury the truth. That's what I'm gonna do.
Here we go.
I'm gonna tell them what hasn't been told to me. I haven't been able to.
Mr. Brooks, I'm going to mute you because we're trying to discuss the jury instructions, not what you're going to say during your closing argument. I'll once again unmute Mr. Brooks and just ask him if he has any position regarding any of these last issues that we've discussed with, as it relates to the jury instructions. Anything from you, sir, on the jury instructions?
He's back at looking at the ceiling. What's over there?
He's not responding to the question. I believe that covers all of the issues that were raised by the parties then. You are. I'll give you one final opportunity to tell me if you have any requests as it relates to the jury instructions, sir.
No headphones, and he's responsive. He forgot that he's deaf again.
Nothing that y'all been talking about, and I say y'all because I haven't been participating in none of that.
I understand, sir. Your objections noted. Your lack of consent is noted.
Okay, I don't see what's going on in there.
Oh.
So how's decisions being made without me being able to consent to it?
Sir, you forfeited your right to be present in this courtroom by your conduct, and you have not requested to come back.
Actually, you took a break. So let's make sure the record is correct. You took a 10-minute break.
I did.
At which time I was brought back into this courtroom.
I was advised you wanted to stay, sir.
Okay, and you've been
Yes, he never said that he didn't say that. He just okay.
forcing me to come over here from the get-go. Why couldn't you force me to come back over here where I'm supposed to be at?
So now he wants her to force him to do something that he doesn't want. I thought that was coercion. Coercion? I don't know how he says it. I thought that was you didn't want that.
Sir, my understanding is you requested to stay in the other courtroom. I thought I put that on the record at the beginning. If I did not, I'll make that part of the record now. I was advised by the bailiffs that you were requesting to stay in that courtroom. I certainly advised you prior to that if there was a time you wanted to come back in, all you needed to do was ask. You've done that previously.
Yeah.
And even during this time, though, you've been incredibly disruptive. At one point you were muted for an extended period of time and you were yelling so loud, sir, we could hear you in this courtroom. I couldn't decipher what you were saying, and I was also made aware that another branch could hear you. So you continued your disruptive behavior.
That's fine, because at the end of the day, I should be heard. I have the First Amendment right to be heard.
Nah.
So if I'm going to be constantly muted, the only way for me to be heard is for me to raise my voice.
Mr. Brooks, one final time, do you have any requests as it relates to the jury instructions? Otherwise, I'm going to approve them. I'm going to take a break, and then we'll come back in the afternoon to go over verdict forms.
I didn't answer yes or no, so how do you consent to anything without me answering the question?
Are you going to answer the question, sir?
You can't force me to do it. You can't just say, I'm going to do this. Because
sir, but you also can't stall the proceedings by failing to answer.
I didn't try to stall the proceedings. You're the one that held me in contempt.
I never held you in contempt.
Never.
All right, I'm going to mute him once again because he refuses to answer a very simple question about whether he has any requests as it relates to the jury instructions. So those will be printed off A set will be provided to the state, a set will be provided to Mr. Brooks. We'll take I'll do a 90-minute lunch break, so it's 11:27. So we'll come back at 1 o'clock to finalize the verdicts and the jury instructions.
All right, I'm gonna leave it here. You just saw the tantrums that Mr. Brooks was trying to do. He was trying to pull off I didn't say anything, so you cannot move on. So he was trying to stall that way, and it didn't work. So join me tomorrow for the next episode of the Darrell Brooks saga. Have a great day. Give it a like if you made it this far. I'll see you guys in the next episode. Bye-bye.